Onward, part 3 for chapter 4, and kind of stopped here talking about motions a little bit, but motions can be questions of law. You know, is this right? Is this admissible? Is this not? Was that proper? Those types of things. It could be on statutes of limitations. We all understand that for some crimes there's a statute of limitations, meaning beyond which a certain period of time, be it 5 years or 10 years or whatever it might be, a charge cannot be brought. Okay, and so sometimes there's motions obviously dealing with that. Sometimes the dates are not always black and white. Judgment on pleadings or summary judgment is saying that, you know, after the complaint and the answer, you know, perhaps the evidence is so overwhelming, and generally the defense would request a summary judgment, asking the judge just to rule on it based on that information. Okay, and that's we had several cases actually when I was at the bank. I know at least one that was a big case that we were awarded summary judgments. So it was common. It wasn't often granted, but like I said, in some cases we certainly did receive that. Affidavits are, why that's under motions. They're usually a part of the discovery. That's just where you ask people to write down their recollection maybe of events. Okay, kind of a witness statement, I guess would be another word for it. And frivolous cases. So a person, I can remember at least once too at the bank where we filed a motion where an attorney and a client had filed a good faith case against the bank, and we felt it frivolous. The judge said yes. We actually proceeded and had, I believe, the attorney fined, even maybe censured for bringing a frivolous case. And so, there has to be some caution. Food for thought, Thomas Jefferson, right? Trial by jury is the only anchor yet devised by man by which a government can be held to the principles of the Constitution. So let's go on. Jury selection. Voir dire, I don't know how to pronounce that in Latin or whatever the heck it is, but to speak the truth. When they call a jury, you know, a jury is usually about 12 people. They don't just call 12. They'll call, 24, 30 people. By the way, my wife just got called for jury duty. She's terribly upset because she hates being called. And on the other hand, I kind of always have said I would like to sit on a jury, and I never get called. So, although I've been in the bigger pool, and I shouldn't say I've never been called, but I can tell little stories about that. But anyhow, challenges of those then. So you have that 30, say, people that are in the jury pool, and you're whittling it down to the 24. And oftentimes there's a bunch of them that get released because they have conflicts. Maybe they know the attorney, maybe they know the victim, or maybe they know the accused. And if it's a criminal case, and so they get excused for those reasons. So then you get to each side are doing challenges, okay? And oftentimes a judge says, well, you'll have 3, 4, 5 peremptory challenges, meaning that you can be removed just basically by that side, more or less for no reason, but it can't be for unconstitutional reasons. Otherwise it would be a violation. So the for cause would be the attorney basically pointing out to the judge that, hey, this person can't serve because they know the victim, they know the accused, they know the lawyers involved, whatever the case may be. Peremptory then, they can do it kind of for any reason. But in the past, and why we say this is in the past there was peremptory challenges used to, say, eliminate all the women that they possibly could, because maybe they wanted as many men on the jury as possible, or vice versa, or racial. Okay, those types of things. There's been some call for maybe elimination of peremptory challenges. One of the racial discrimination went way back to here, and gender only back to 1994, right? So not that long ago. But there's currently a division on the issue of banning discrimination based on religion, and that's kind of interesting, isn't it? when you think about the diversity of the United States and you think about the terrorist things and those types of actions that are taking place, could you eliminate certain religions from serving on a jury when maybe the accused, or if you were the plaintiff, or in this case like the county or the state, could you eliminate certain religious people from the jury that might be sympathetic towards the accused? Those are tough issues, and so that's why they're kind of divided on that. So, the trial, you go through jury selection, opening statements. Both sides make an opening statement, overview essential facts, present the evidence, which means calling witnesses, entering evidence, doing those types of things, and then the request often for a directed verdict. Okay. This would be after the case, basically. They probably a motion for a directed verdict, and the judge could rule and could say to the jury, hey, this case is overwhelmingly, this guy's either guilty or innocent, and I'm directing you to enter that verdict. And they would. Okay, and that would be the end. Essentially, it would take the jury out of the process, and the judge just saying that the case is so overwhelming that we have to, enter this type of verdict. Then there's closing arguments, instructions to the jury. Often these are things that go up on appeal, where the instruction is appropriate. The admission of certain evidence was that those types of things are the things that oftentimes get appealed. And then you have the jury verdict. Okay, and remember, in a criminal case, that jury verdict has to be unanimous. Okay, it's beyond a reasonable doubt, and that means a unanimous verdict. Okay, in a civil case, a suit, let's say a lawsuit from one person against another, then it's a preponderance of evidence. We define that then as probably being a majority. And again, jurisdictions may differ. In some cases, it may be a supermajority. Maybe 3/4 or maybe 2/3 of the folks on the jury have to agree. And basically, what I just was saying. Okay, burden of responsibility of evidence. The plaintiff has a burden of proof. Okay. The defendant, a burden of refutation is kind of what they would call that, but that wouldn't be on any test. Anyhow, criminal cases are, again, beyond a reasonable doubt. And again, that means a unanimous jury. And civil cases, a preponderance of evidence. There has to be clear and convincing proof, but not necessarily certainly not unanimity amongst the jurors. So judgment, in a civil case, we call it a judgment, right? There's a judgment for one side or the other in favor of the party that won the jury's verdict. A judge can issue a judgment notwithstanding the verdict. And I've only seen about one article in all the years I've been teaching this and following the news and whatnot where a judge actually did issue a judgment notwithstanding the verdict, meaning that the jury came back and gave a verdict, but after pondering it, maybe the judge said, no, the jury's incorrect here, okay, for certain reasons, and overrules the jury, basically, and makes a judgment that's notwithstanding the verdict. So that's a post-trial motion. It's counter to the jury's verdict. My guess is it's extremely rare, okay, but again, in my years, I have seen at least one article where it did mention a judgment notwithstanding. They have it appeals. Appeals, then, we don't go back through the whole process. We don't call the same witnesses. We don't make the same arguments, but both sides file briefs. Briefs is a total misnomer because, generally speaking, those things are pages and pages, or like small books, okay, sometimes large books. They do make oral arguments, so both lawyers, both teams are allowed to make oral arguments in front of the court, and then the judge or justices, and oftentimes in these cases, then it's a panel, okay, unless you're going like before a federal judge, but oftentimes it's a panel then that hears this and makes those types of decisions. The deference to the trial court, certainly on the factual basis or a jury's conclusion, there's deference to that, but they still look for those types of things. So in other words, deference means that the trial court's version is going to be upheld unless the appellate court finds a compelling reason to overturn that, right? Enforcement of judgments, in this case. This is after the post-trial and you've received a judgment, the winning party would be allowed to execution here does not mean killing them. Execution means the ability to obtain property or payment. Okay, and that's a difficult thing. You know, it was one thing to get a judgment from a court. We often did. Collecting the money was a whole other thing. And execution generally meant for us, it meant that you could, for example, if you knew they had a bank account at Wells Fargo, you could ask the court to serve Wells Fargo, and if they happened to have any money in their account on the day they got served, okay, you would get that money. Okay. Now the problem with that, of course, is you don't have any right to ask what bank they might be at, and two, even if you got so lucky, you know, if once you executed one time, obviously they're going to close that account and go open up an account in Timbuktu or someplace, and you're probably never going to find out about it. So execution was really difficult. I'm not going to tell you that it wasn't successful in times, okay, but but it was really difficult to be successful. You could also execute against other properties. You could enforce judgments against real property and personal property, household items, those types of things you could not. Okay, so personal property would have to be, you know, a vehicle or something like that. So often when you're having that kinds of problems, if you wanted to, say, execute against their vehicle, the problem was they probably already had liens against their vehicle, and those were priority liens, probably purchase money security interest liens. And so you didn't have much success there against other properties. I recall some executions against bank accounts where we were somewhat successful. You could execute sometimes against cash streams, you know, if they were happening to get some type of annuity payment or something like that. And sometimes we were successful there. We never, to my knowledge, were successful executing against personal property, sometimes against real property, having our judgments imposed on real property. It wasn't that we ever took that, I don't think, to the extent of a foreclosure, but usually it brought the person to the table to make some arrangements. And then garnishment was against a person's wages. And that we did often. Okay, we would often garnish a person's wages. Again, it was difficult, and here's the reason why. You could garnish no more than 25% of their wage. So if you had somebody that was working weekly, let's say, because these were the most difficult, you could get, and let's say they made $200 a week, part-time employee, whatever the case may be, 20 hours a week, $10 an hour, you'd get $50, right? It cost back then, you know, $40 or $50 to have the service processor, be it a sheriff's account or there was a private person that did it, go and serve that employer. Well, the employee then, that $50 that came in, it first went to pay that service processor, and then whatever was left was applied to the account. Obviously, there wasn't much left. You know, if you were lucky, they got paid by the month, and then it would be a little bit more successful. We'd still do that sometimes, and once again, it was just to bring the person to the table. When they realized that, you know, they were going to have their wage garnished, number one, and number two, it really wasn't going to pay down their debt, they'd oftentimes call you up and sometimes set up like even an employer withdrawal, you know, an automatic payment from the employer. Some employers are pretty good about those things. You know, if the employee was a good employee, they didn't want to lose them, you know, they'd agree to take $50 out a week and send it right to us. So doctrine of res judicata just means it's over. It's reached the end point. Maybe an appeals court refuses to hear it. Okay, that means it's over. It's done. Can't go any further. Directed verdict refers to the power of court over parties involved, power granted to litigant, power of court to order sworn, power of court to grant a decision in favor of defendant when insufficient evidence is presented at trial. There you go, huh? Piece D, right? It's class action lawsuit. Depositions, we kind of talked about it. Can you decline to testify at the deposition? Yeah, you can, but you can also be subpoenaed then. If you're subpoenaed, they have to pay you some costs and whatnot and those types of things. This was a question I think it has to do with the case maybe that's in the book, but we didn't really discuss that. So there you have it, the end of Chapter 4.